Welcome to Skills to Pay Your Bills. This is the special segment called the Wealth Zone University, and I'm your host, Don Moragne. Welcome. As you know, the credo of the Wealth Zone University is to change your mind about money so that you can change your financial future. Today, we're going to be talking about business, and we're going to be talking about business and taxes. And we have as our guest an astute attorney who knows more about taxes than I'll ever know. And I want you to get to know him and get to understand what services a business needs in order to make sure that they have a good relationship with Internal Revenue Service, if there's such a thing. My guest today is Charles Ray. Charles, welcome.
Thank you, Don.
Good, good. Could you tell us a little bit about who Charles Ray is?
Sure. Don, I'm a native North Carolinian. After being born and raised there, I went to college in Pennsylvania, in Haverford College. Worked for a year and a half on the Hill with Congressman John Conyers as his press aide. And he was influential in encouraging me to go to law school. So I went back home to law school, went to the University of North Carolina at Chapel Hill, initially with the idea of running for public office. But along the way, I became very interested in the tax law. I was fortunate to have an excellent tax professor who taught all three of the courses there.
Okay.
And after graduating from there and becoming a member of the North Carolina Bar, I came to Washington, D.C., where I worked with the Chief Counsel's Office at the Internal Revenue Service.
Internal Revenue Service. And that's where Charles and I met. We won't say when we met, but that's where we met.
Quite a few decades ago.
Now, when you worked for the Internal Revenue Service, you said you worked for Chief Counsel. So what is that?
The Chief Counsel of the Internal Revenue Service is pretty much like it sounds. It is the attorney's division that advises the Internal Revenue Service both in the national offices and in the district offices across the country. My first job was in the interpretative division, which was a lot of fun because we got issues that, by definition, no court or administrative body had ever considered. So our job was to research as extensively as we could what the tax law was and then create a solution.
We're going to talk about that later on. That has a definite meaning that I think we need to share. And when you and I met, we were working on a task force that dealt with, let's say, just say highly visible compliance issues.
Yes,
you know?
Yes, we did.
And I know you're asking, why do we both have this spot of gray hair? We got that from the time
from that compliance
we were
task
working
force.
on that compliance task force. Then you left the government and you opened your own practice.
Yes.
Okay.
After, I worked for a couple of years with as a general counsel to a mortgage loan servicer, and then I moved with another law firm and decided to start my own practice after that.
Okay. So tell us the name of your practice. Tell us all about it. We need to get to know your practice and your expertise. Well,
my tax practice is the law firm of Charles A. Ray. I am the principal. We have several administrative persons and a host of counsel attorneys across the country that we work with. But our primary focus really is just to continue the expertise that I developed while at Chief Counsel IRS, and that is handling tax matters for individuals, small to medium-sized businesses, and other business entities.
So I need to tell you that in our financial management practice, all of our tax work has gone to Charles for decades.
Yes, it has.
From tax court down to just normal resolution work. So tell me more about the services that you do. What are the services that you do for the average American public, and what are the services that you do for the business American public? And at some point in time, tell us about the tax court successes that you had also.
Okay. With the individual and business tax issues can sometimes overlap. Business owners, as all business owners know, can be personally liable for the employment taxes and the unemployment taxes. That's what the IRS calls the civil penalty. So to the extent that a business has a business employment tax that goes unpaid, not only is the business liable for it, but the individual persons who manage and operate the business also can be personally liable.
Okay.
So our job essentially is to manage resolution of any tax controversy that arises when the IRS says that either a business or an individual owns a certain amount of taxes, and that individual or business either agrees with it but can't pay it, or disagrees with it and wants to challenge it. So in both instances, we marshal all of the available resources to advocate the position that is most advantageous for the client.
Okay.
When we go to tax court generally is the result of an unresolved liability between the IRS auditing function and the taxpayer. Many people should know that just because the IRS contends that they owe a certain amount of tax doesn't automatically make that correct. The IRS
Right.
is simply proposing.
Did you hear that, America?
The IRS is simply proposing an adjustment to your tax, always in their favor, but it is just that, a proposal. So the taxpayer has an opportunity to go to tax court to challenge that, and we provide that representation of the taxpayer in the United States tax court, which involves filing a petition and meeting the trial schedule that the court orders.
So your firm can represent people at the federal level, but also at the state and in certain jurisdictions, right?
Exactly. Because federal tax law is just that, federal, we can represent taxpayers before IRS all across the country, and we do. We have taxpayers literally across the country for IRS matters. But also the states, most states will recognize our representation, because we do represent, we are authorized to represent before the Internal Revenue Service, and we are licensed as attorneys in both the District of Columbia and Maryland. So for example, we're handling a case, the most recent case we had came in last week is in Alabama. And the Alabama Department of Revenue has recognized our representation of their resident at the state level, whom we're also representing in the offer and compromise process at the federal level.
So one of the things that I get a lot of questions about, and I'm sure you do too, is about things like, what is an offer and compromise? What is this fresh start that IRS is talking about? Give us some just information on what those programs are and how they can help.
Okay. Well, Fresh Start is the initiative that IRS instituted back in 2013, and they continue to revise and update. But essentially, it says that taxpayers with a liability generally under $50,000 who can pay that liability within a certain number of months that is to be negotiated, not to exceed 72. Generally, the IRS will, one, accept an installment plan for them without filing a tax lien under certain circumstances, and which can be crucial for many taxpayers without requiring any additional financial information. That works to many taxpayers' advantage, just on on those factors alone. In other instances, the IRS has indicated that under certain circumstances, they will withdraw a federal tax lien as long as the taxpayer we put in place a direct debit installment agreement, either from payroll or from bank account, and will also allow the liability to be paid, over a certain period of time.
Okay.
Rather than requesting it all at one time, and rather than levying on bank accounts or garnishing wages to collect. The offering compromise is pretty much what it sounds like. It is where the IRS has agreed to accept less than the full amount of tax due based on the financial resources of a taxpayer.
Okay.
It may seem counterintuitive to taxpayers who say, well, gee, I don't have any money. I don't want to try to resolve my tax debt. Therefore, I'm going to ignore the certified mail that comes. That is absolutely the wrong thing to do. But it is counterintuitive that if you don't have, financial resources or enough to pay the full amount, it's counterintuitive to go to the IRS, it's counterintuitive to open the mail pretty much saying what you already know, and it's not very good.
Right, but you should sign for that letter and take it to a tax attorney.
You should
right?
do it, and if you can't open it yourself, we open so many, certified mailings. Take it to your tax advisor, even unopened, but as promptly as you can, because letters like that often have a time limit for response. So if it's just not in you to open it, just gather it up, bring it to your tax advisor. They will open it and get you started on a resolution that in many instances is a lot, maybe not a lot simpler process, but not as painful a process as taxpayers think, especially when managed well. And one thing that we want to do, number one, we want to solve the tax problem, but we also want our clients to feel better after their first conversation with us. And I've had clients, if they don't feel better after telling me about their tax problems, I won't let them go.
Okay.
I'll say, you can't leave my office until you feel better about you're paying me this money, you're giving me all of these papers, you've got to walk out feeling better.
Well, see, I know that all the people that you helped are not sitting in your office now. So obviously, you've not only made them feel better, but you've helped them. And so when you try and make them feel better, you just try and essentially make them understand what the process is and that there is some light at the end of the tunnel?
Yes. I mean, we let them know that essentially the fears that they have are often exaggerated. I mean, certainly there's a fear you have about not paying your taxes. That's a reasonable fear. That fear will prompt you to action. But, what collection action the IRS can take, what are they likely to do, what risks are you exposing yourself to are often exaggerated and blown up simply because, you feel like you're not addressing your tax problem. So we manage, the reality of what the consequences are, what their rights are, and what the IRS's enforcement mechanisms are, and how we can navigate their resolution so that they don't get subject to bank levies, wage garnishments, or seizure of personal assets, including the home.
Okay, we're going to talk more about that now. We're going to take a break for a couple of minutes so that we can do some administrative stuff with you. And then we're going to come back and talk with Charles about some more tax information, but we're also going to talk about what business owners need to be thinking about in terms of legal advice, legal counsel, so that we can make sure that that is an area that we touch on, okay? We'll be right back. Don't touch that dial. Hi, everyone. The objective of the Wealth Zone University is to change your mind about money to change your financial future. Hi, I'm your host, Don Moragne. In the Wealth Zone University, my guests and I talk about a wide variety of business, financial, and other worldly topics. We are seeking to both educate and entertain you. We emphasize that the informations and discussions are my opinion, perspectives, and ideas, and those of our guests. We in no way intend to deliver or provide financial, tax, or business advice. You should consult with your tax, accounting, financial, insurance, and legal advisors regarding the impact, application, or pertinence of any topic or opinion that we share on the Wealth Zone University. Thank you for being a part of our audience, and please continue to communicate with us through email and Twitter, because this is your show. Welcome back. We hope you had an informative break. We're going to get right back into our topic today with our guest, attorney Charles Ray. And Charles, before we left for break, you talked about the offering compromise and how IRS would take less money than you owed. Can you give me some more background on that? Is that really something that IRS will do, take less money than it's owed?
Yes, it will. The IRS is the revenue-raising body for the federal government. And the question that they always face is, what is the most amount I can collect at the least cost? So the IRS has, Congress really passed a law that enables the authorizes the IRS to accept less than the full amount of the tax debt under essentially three circumstances.
Okay.
One, when there's doubt as to collectability. Doubt as to collectability simply says, I, the taxpayer, agree with the amount that the IRS says that I owe. I simply don't have the financial resources to pay it. And there are various formulas and various forms that must be completed to fit within that category, but that is one of the categories.
Okay.
The second category is doubt as to liability. And that is essentially where the taxpayer says, the IRS is saying that I'm legally obligated to pay this tax, but I'm not. As a matter of law, I don't owe it. And the legal reasons that you don't owe it could be multiple. Mm-hmm. The most common that we have been seeing recently, and you probably run into quite a bit, is in the audit reconsideration cases. Audit reconsideration is short of saying that the IRS during an audit said that I owe this tax, but the audit was wrong. And a simple example is, your investment company gives you a 1099 of a gross distribution that that was paid in a connection with the transaction, mm-hmm. but it doesn't take into account your cost. Mm-hmm. Mm-hmm. Or when you sell a house, the contract sales price is the 1099 amount mm-hmm. that is sent to IRS, and that's what IRS is trying to collect. But that's not the amount that the taxpayer received as cash out to the seller, mm-hmm. From the transaction. Well, audit reconsideration had been one of the ways of resolving that, mm-hmm. but it's a very long process simply because there are only about 8 or 10 people in the country who do it for the Internal Revenue Service.
Okay.
So it's not unusual for that process to go 3 years.
Wow.
Doubt as to liability offering compromise is less than that period of time, and the law says that if the Internal Revenue Service does not approve an offer within 2 years, then it is automatically deemed accepted. So those types of cases are good cases to present, number one, because they offer a faster resolution than the audit reconsideration mm-hmm. process, and two, because if after 2 years, if it's not processed, it's deemed accepted. And the last category is effective tax administration. Effective tax administration simply takes into account the taxpayer may have financial resources to pay it, but there's something about that taxpayer's particular situation that would make it unfair to require that taxpayer to pay the full amount.
Unfair, okay, that's a concept that I didn't think IRS was about.
It could be unfair or would cause an economic hardship. And one simple example that we run into a lot is especially with aging parents and persons who face catastrophic illnesses or catastrophic accidents. I mean, we had a young couple who's, one of whom was in a car accident where they were, pretty much permanently disabled, not able to work, but had a huge tax liability. And we were very fortunate in being able to get a compromise of that tax liability at a very small fraction of that, based on the fact that the financial resources of the family would be needed to, for the care of the spouse going forward, and that the current financial resources, simply, if applied to the tax, mm-hmm. would cause the family a financial hardship. Okay. So those are the three categories.
So is it fair to say that because of your IRS experience, your success in these resolution matters is higher? Do you feel that your IRS experience does contribute to your ability to successfully prevail in these cases?
I think so, Don. And the reason is that, when you talk to I talked to Internal Revenue Service personnel, for 8 years of my professional career. Mm-hmm. And I like to think that over that period of time, I learned how to talk with them, what to say, what their interests are, what the sticky points are, mm-hmm. and how to present a case in the light most favorable, to the client without seeming like you're trying to get, a taxpayer off the hook, so to speak. But, that's one area, simply the interaction, both, verbal and written. And in reading the various cases and, the new regulations that come out, the new laws that come out, I mean, that's what I did, for 8 years. So I get a sense, a feel for it. And I like to think that, that comfort and that knowledge, does come through. And it makes it removes, I think, some of the adversarial tone that one could otherwise have, or one would otherwise envision between an attorney for the taxpayer and the Internal Revenue Service.
I asked Charles that question because, again, we came out of IRS together, and I tend to think that we're pretty smart guys because we had the experience with the old IRS where training was really, really one of the main priorities for its enforcement employees. So offering compromise, is that the first thing that I have a tax problem that I come to you with? I mean, is it possible that offering compromise is available and successful for everybody, or is that something that is in the specialized 4 or 5 cases, actually matters that you talked about?
Well, an offering compromise, frankly, isn't for everybody.
Okay.
One, the taxpayer has to fit within one of those criteria. And secondly, and probably most important, is that the financial resources, or the net monthly income of the taxpayer cannot be such that it will pay off in full the total amount of the tax debt over what IRS calls the collection statute. And the collection statute is 10 years. So for example, a taxpayer with a $5,000 tax liability who has a net income of $1,000 a month is not a candidate for an offering compromise.
Exactly.
He or she would be a candidate for an installment agreement at a small amount, but not an offering compromise.
Okay. But when a client comes to you, you evaluate the merits of the type of approach and program that you're going to go recommend to that client.
Absolutely. I mean, our first analysis of a taxpayer's case involves both an analysis of an installment agreement potential as well as the offering compromise potential. So if one isn't feasible, the other is, and we will explain why as to both. But one thing also, Don, if a taxpayer doesn't qualify for an installment agreement or for an offering compromise, we may be able to put that taxpayer into what the Internal Revenue Service calls a currently non-collectible status. Currently non-collectible means, well, at least for a year, sometimes 2 years, we, the IRS, will not try to collect this tax from you. We won't try to garnish your wages. We won't levy your bank account simply based on what we understand to be your financial resources. And we have cases like that. And the good news about that is the taxpayer doesn't face any enforced collection action like levy or garnishment. And the statute of limitations on collection continues to run on the IRS.
Okay, so that 10 years is still starting to wind down.
It starts to wind down. So that's another resolution possible.
But again, that in order to be currently non-collectible, there has to be some financial situation that you evaluate and determine whether or not that program can possibly have benefit to the particular client.
Right. We evaluate the financial resources of the taxpayer, obviously in confidence. We want full disclosure of all financial information, all financial resources, so that we can start with all of the information that is available and craft the resolution that's best for the client and that's most likely to be more readily accepted by the service.
And in tax matters, both on the tax side and the law side, we tell the client, tell us everything. No surprises. Surprises are the worst thing in the world. Am I right?
You are right. You are right.
So I know Charles makes sure that he gets all of the information that's available so that the determination of how to go is made within the context of having full knowledge and full disclosure from the client.
Indeed.
Also in your practice, you deal with business matters that aren't necessarily tax related.
Correct.
So what are some of those things that a business owner who's watching us would need to talk to Attorney Charles Ray about?
Well, one of the first things would be, entity, choice of entity, choice of what structure you want to have your business become. Is it a corporation? If so, is it a C Corp? Is it an S Corp? How about a limited liability company? And a lot of the answers to what entity is best is going to be determined by the type of business activity the client wants to engage in. Mm-hmm. Real estate persons, for example, tend to do better with limited liability companies for separate parcels of property, mm-hmm. generally. Mm-hmm. LLC, well, what we call series LLCs, where you can have a number of limited liability companies, under under a limited liability company.
Like an umbrella company.
Like an umbrella. That's the first. The second is really in structuring transactions, reviewing transaction documents to determine are there any issues that arise that we can structure in a way that is more favorable on the tax side to the client. That is probably something that's often overlooked by business owners of just about every type. Mm-hmm. And for that type of contract review, we try to keep the fee, relatively nominal, because if we're just reviewing it, we want to be able to read it and discuss it openly. And if there are any additional services to be performed to implement some of the solutions that we see or implement some of the recommendations, then we'll let them know that. But, contract review, transaction review for structuring, and, really not wait too long to come to us about any matter, especially employment taxes.
Charles, thank you for being here today and sharing with our audience. As usual, we think we brought you some of the most pertinent information with the most professionals that we can find. We'll see you soon. Take care.